Yes.
Maybe. Back to mention item number 10, my lord, admission matter. My lord, this matter has become infructuous, my lord. So it may kindly be closed, my lord.
Item number 10,
10, my lord.
not admission, it is hearing.
It has become infructuous long back, my lord.
No, it is not for admission, it's for hearing.
Yeah, my lord.
What is the case number?
My lord, it's 7-5.
7155 oblique.
7155.
Why it has become infructuous?
My lord, actually, this petitioner and others were made members of a block level committee long back in 2013, my lord. And thereafter, my lord, the respondent, the deputy commissioner wanted to remove them. Again, that removal, my lord.
Mr. A.R. Talukdar, learned counsel for the writ petitioner submits that the term of the block development committee has expired long back and
No.
therefore the writ petition has become infructuous. Ms. M. Burman, learned government advocate, Assam, is present on behalf of the respondent. Taking note of the submission of Mr. Talukdar, this writ petition stands disposed of as infructuous. Interim order passed earlier shall stand vacated.
Obliged.
I beg to mention item number 3, my lord. In this matter, we have filed affidavit, but same is not tagged with the court record, my lord. Can it be taken up on Monday, my lord? I have taken the consent of others, sir.
On the request of Ms. M. Burman, learned government advocate, Assam, made with the consent of the opposite party, let this matter be listed again on Monday, date to the above,
Obliged.
by tagging the counter affidavit filed by the
Respondent number 4.
respondent number 4 with the record of this case. Yes.
Obliged.
Lordship, in item number 14, Lordship, we have filed an affidavit in opposition that may kindly be called for.
Yes.
Lordship, I'd like to mention for listing on the petition.
Listing, what listing? Motion?
No, Lordship. Or orders, I think.
What
Notice
order?
was- Notice was issued, Lordship.
Yes. What order is required?
Lordship, it was last listed on 27.
After 2 weeks. Yes.
Obliged, Lordship.
Supplementary list for motion items.
May I please, Your Lordship? My lord, in the case, my lord,
My specific instruction, in fact, from the Honorable Chief Minister is that, my lord, we'll take care of them for 3 months by providing shelter, ration and water. And in the meantime, my lord, if they file their application for allotment of land, we'll consider in terms of the land policy of the government. my lord.
All right. So we'll dispose. Can you file a short affidavit? We'll dispose it off. That's all. What else?
my lord, only
Let them file a
My
short
record, my
affidavit.
statement, it is on.
No. There has to be an affidavit on that. What is the problem? We'll
Problem is
dispose
that I
it.
have to again get, because it pertains to BTC, my lord, it has to be filed by someone from BTC. Or,
What is the problem? BTC is within this.
my lord, it will take some time, my lord, because my lord, my instruction is on WhatsApp, my lord, from Honorable Chief Minister. I have to communicate with the Commissioner Secretary or Secretary, then. But otherwise, if my lord records my statement, my lord.
my lord, affidavit is, if it is given, my lord, into it will be kept in the record, my lord.
That's my statement, my lord.
We'll issue a direction then, take
Exactly.
note of his statement.
Exactly, my lord.
Only, my lord, apart from this, my lord, whatever lordships convenient, my lord.
Hmm.
Only, my lord, geo coordination has to be done, my lord, because the report is the only one man by paper only.
Mr. Balbuya, you have not read the last order. You
Last-
haven't read. Probably you didn't get time.
my lord. Because it is there.
You are occupying Sarkari land. You
Yes,
have to
ma'am.
vacate it. As simple as that.
my lord.
Whether it is done by geo coordinate or some other coordinate or artificial intelligence, the fact is that you are in occupation of Sarkari land.
If it is government, then, my lord, I'll get some protection, my lord.
So what protection?
Some protection in this. I can file application and they can go for, if they want, they can give.
No,
settlement.
these are all prolonging methods. We will not allow law to be used in this manner. Sarkari land, the government wants the land, you have to vacate. Only right you have is you cannot be thrown out in this state. Your safeguards under Article 21 has to be adhered to. That they are willing to do.
Last. Last.
What else is there to be decided here? These are all, they did not do this, they did not do, these are all to cling on to the land.
My lord.
This court will
His
not permit
submission,
all
my
these
lord.
things.
My learned friend submission
ma'am.
to the court.
Yes, ma'am.
Heard Mr. J.I. Bolbhuya, learned counsel appearing for the writ petitioners. Also heard Mr. P.N. Goswami, learned additional advocate general Assam, appearing for the respondents,
Last.
assisted by Mr. S. Rabha, learned SC BTC, and Ms. N. Bordole, learned SC Standing council appearing for the respondents, full stop. On 19/9/2023, this court had passed the following orders by taking note of the contention of learned counsel for both the sides. Quote the order. Full stop. Today, when the matter is called up, Mr. Goswami submits on instruction from the highest authority in the state that if the petitioners vacate the land on their own within the time permitted by the court, then the state respondents will provide necessary food, water and shelter and other basic amenities to the petitioners and their family members for a period of 3
3
months, by which time their applications for allotment of land would be considered and a decision will be taken
In terms of land policy of the state. my lord.
in terms of the land policy of the state. Full stop. Mr. Borbuya at this stage submits that some time be given to the petitioners to vacate the land on their own.
My lord, we'll file application also, my lord. We'll file individual application also.
And also for filing individual applications for allotment of land, full stop. Since Mr. Goswami has given a categorical assurance to this court that the basic amenities, including food, water and shelter will be provided to the petitioners if they voluntarily vacate the land under their possession, it would not be necessary for this court to enter into an adjudication as to whether the land under the occupation of the petitioners falls within reserve forest or is it a Sarkari land located within revenue village. The fact remains that the petitioners are encroachers upon Sarkari land and therefore they are bound to vacate the same if the land is required by the state, full stop. As such, taking note of submissions made by learned counsel for both the sides, this writ petition is being disposed of by providing 3 months' time to the writ petitioners with effect from today to vacate the land, the respective land under their occupation by removing their belongings therefrom. Full stop. In the meantime, the petitioners may submit application for allotment of land as per the land policy. Full stop. If the petitioners fail to vacate the land within 3 months as permitted by this court, it will be open for the respondent authorities to proceed against them for removing the encroachment without serving any further notice. Full stop. The respondents shall intimate the petitioners at least 30 days in advance as to the arrangements made for food, water and shelter, oblique rehabilitation of the petitioners as per the observations made herein above. Full stop. It is also made clear that until such time, the applications for allotment of land made by, if any, made by the writ petitioners individually is considered and a decision is taken in the matter in accordance with law, the respondent shall continue to provide shelter and other basic amenities to the respondents, which are befitting of befitting human standard. Full stop. With the above observation, this writ petition stands.
One line to be added, my lord. If the decision is taken in my favor, my lord, in that case, my lord, there shall not evict me, my lord, because by virtue of lordship's order, they will be given. Only that one.
All right.
If
You
the-
inform him by phone, what is the decision? They will take the decision after you vacate the land. Where is the question of not evicting?
My lord, I got a structure also, house also, school is also there, masjid also there.
No, but Mr. Borbuya, I asked this question to you on the earlier day. Coming and occupying Sarkari land, you can't get the protection of the court order to continue in that
My lord,
land.
only
That
one.
law is not there in your
My
favor.
lord, if the decision is taken in my
Then
favor,
also they will not get the allotment in that area.
You may not get that land.
That's a forest. land.
It's time that these things are handled. The court will be concerned about violation of human rights, Article 21 right. But you cannot just come and occupy Sarkari land and then say that give me allotment, otherwise I will not
My
vacate.
lord, in that,
That legal regime is simply not available. And as judges, we have to do justice in accordance with law.
my lord.
So
My
what is the option left for the
My
court?
lord, in certain cases, it has been seen, my lord, honorable court has taken so much of PL, my lord, they kept in a camp, my lord, they are dying, my lord, without food, water.
That is another matter I have mentioned, which is befitting of human standards. So if that doesn't happen, but there is a problem here. There
Yes,
is a
but
problem and this problem cannot be sorted out unless we move forward.
my lord,
We have to see someday.
they have
how
to
this-
give us protection for my lord, right to security.
Oh, they will give you a security and a vehicle,
Not that, my lord,
then
life to, my lord, that.
Only one thing,
food
my lord.
security, my lord.
In the
that's not
order,
possible. You are encroacher.
My lord, I am
Encroachers cannot
encroacher, that
get
is
out.
true.
Go back to your ancestral land, as simple as that.
I do not have authorization, or I would have not. stayed.
my lord, only one thing, my lord. In the order, my lord, that second paragraph, my lord has indicated as Sarkari land, oblique forest land may be recorded. Else, my lord, they will again take a plea, it's a
Or Sarkari land oblique forest land.
deep level.
You have accepted the order of the landed single judge earlier, that they have to verify.
My
They
lord.
have given a report that it is
My lord,
reserved
the
forest.
report
land.
is correct, my lord, but the report they have not done in a method which they ought to have done. my lord.
According to you,
No, my lord, as per
according to
the-
them, they have done it in the right method. How can
my
the
lord,
read code go
without
into?
consulting single record, my lord.
Then you file for contempt if it is a false statement. How is the court supposed to decide those things?
My lord.
Then
My
I have told you on two previous occasions that your clients are in a very narrow space unless you come up with a concrete case. These protections can't be given. The read court cannot pass a blanket order, no eviction.
No,
We
my-
will only see in the process
my
whether they
lord,
are.
if it is
violating-
done geocoding once for all, my lord, their problem will be our problem for the petition.
All right, next matter, please.
Lost.
My lord, one line, my lord. Petitioners who are homeless, my lord, landless, my lord. Only landless word, my lord.
That you see when the application is filed.
Obliged.
Daily list, item number 1 will be taken up as the last item. Item 2.
May I please, your lordship? My lord, this case relates to the, my lord, detention of,
Lordship, as per last order, the case was fixed on 14/9/2023 before the executing authority. And Lordship, I have received instruction, nobody appeared on that day, Lordship. And
no, my lord, what they did, my lord, they are,
Just a minute, just a minute.
ব্যক্তিতে দিয়া জানা original আনিস।
Yes, what was the last date fixed?
on 14/9, Lordship.
My lord,
14/9
what they are doing, my lord, they are sending documents by backdated, my lord. I brought the original. Lordship, kindly see the stamp.
So when is the next date?
Lordship, next date is not fixed. Lordship may fix a date, asking them to appear on that day, will take up the hearing on that day, Lordship.
Hearing, my lord, that will after by first week, my lord, that is altogether different, my lord. Honorable court asked, my lord, particular
No,
order.
no, please. Don't digress, Mr. Bobia. I found that you digress and go somewhere else.
My lord,
The only question here is, you have to be given an opportunity of hearing.
my lord,
The last date, they say you did not appear, you say you did not receive notice.
I have to.
So therefore, we will only focus on the next date when you will have to appear. So when is the next date?
Lordship, department is not fixed. Lordship may fix. a
Both
date.
of you agree, will pass an order.
Yes,
My
Lordship.
lord, apart from this, my lord, honorable court directed, my lord, lordship, kindly have a look, the last two orders, my lord.
Hmm.
They need to place some document, my lord. Lordship, kindly have a look, the last order.
What document?
Unless and until Lordship, hearing took place, order is
Lordship will
passed.
see 1923, my lord. Order dated 1923, my lord. Simultaneous order, my lord, they are skipping that, my lord.
What document? There is no mention of any.
Yes,
document.
my lord, they are to apprise the court on 8/9 as to why the order have been passed relation to a section 115.
Yes, Lordship, that order is to be passed after hearing is took place.
Heard Mr. J. Bodwell, learned counsel appearing for the writ petitioner, also heard Mr. S. V. Kyle, learned Standing Council Customs Authorities appearing for the respondents. By referring to the order dated 8/9/2023, Mr. Kail submits that although the date of hearing was fixed on 14/9/2023 before the
Lordship, Superintendent, Adjudication, Custom at Shillong, Lordship.
Superintendent of Adjudication Customs at Shillong, the petitioner did not appear before the authority on that day, as a result of which the hearing could not be conducted. Full stop. Mr. Borvia, on the other hand, submits that his client did not receive any notice, as a result of which she could not appear. It is also the allegation of the petitioner's counsel that backdated notices are being sent to the petitioner so as to ensure that she is not present on the date of the hearing. Full stop. Full stop. By order dated 8/9/2023, this court had directed the learned departmental counsel to appraise this court as to whether any order has been passed under section 115 of the Customs Act in respect to the vehicle of the petitioner. Full stop. Such an order, obviously, could be passed after conducting hearing in the case, which did not take place on 14/9/2023 for the reasons stated at the bar. Be that as it may, in order to avoid any further confusion in the matter, this court, with the consent of learned counsel for both the sides, fixes. What is the date? Give the date.
What's my understanding can give it date.
My lord, till first week, my lord, any day or
Why don't you choose a date?
uh,
You have the option now.
on
6.
7th of October,
16.
on 11, my lord, on 11 October.
On 11th of October, bracket Wednesday, 11th of October 2023, bracket Wednesday. Before the respondent number,
Lordship, Lordship, before the Superintendent Custom.
before the respondent number 4.
Lordship.
Full stop. No further notice of hearing, since the counsel for both the sides are present before this court, no further notice of hearing will be necessary. In this case, petitioner to appear before the respondent number 4 on 11/10/2023 at 10 AM. With the relevant documents for the purpose of hearing of this case. List this matter again on 20th of October 2023, on which date the learned standing counsel for the respondents to produce the outcome of the process, as well as order, if any, passed by the
Lordship.
respondent number 4.
Much of.
List accordingly.
Supplementary list for admission item 30.
Your Lordship. This is the matter which on the last occasion came up on last Monday, I suppose. Well, it relates to cancellation of my license to carry the food grains on some unsubstantiated and false allegations, blaming me for the crime, whereas some other people have committed the crime. Well, if I just take your Lordship to the FIR they have lodged, which unfolded the entire incidents, that your Lordship will find the
Which page?
FIR is a page. Page 57. Yes. And we come to page 57. What it says. I'll read it, my lord. With reference to the subject, subject is FIR against the Secretary and Board of Directors of Mrs. Rohmodia SS Limited, Samabaj Committee Limited, Rohmodia under Dibrugarh district, has involved in illegal business of TPDS, Targeted Public Distribution System rice under National Food Security Act 2013. Particulars of the accused has been given, my lord. These two persons. Tuleshwar Guhai, so and so, so and so. By profession secretary of Mrs. Ramoria, so and so, this society. And Mrs. So and so, represented by Pranjal Borua, chairman of the board of directors. They are the two accused persons. I am the contractor who used to carry and deliver it to them. I delivered everything to them. It was lying in their godown. For the second year, they didn't issue any order to me that you go and distribute. Instead, what they did, they wanted to distribute themselves by exchanging the real rice bags. And there, those fair price of.
Where is the order of cancellation?
That lordship will find at page 66. Now they fall back on the terms of the agreement, which I have not violated, and they say that your license is cancelled. They have dragged me here.
Work has been allotted to someone else.
Not yet allotted. I'm there.
Your client was heard before the order was passed.
I was given a so-called, I have given the answer. After no hearing, just of the order.
So, but it says during personal hearing,
Personal hearing, April person, sorry. Personal hearing was given, yes. Written submission was made. To be one page.
the tier one is from where to where?
From the food corporation go down to the GPS go down. That is the tier one. And then in the tier two, when they will ask me to distribute in the agents, I will take it and distribute to them. Now, they have categorically mentioned that those were there. First year, I got it and it was there in the go down. And there, this president, secretary and all that, they manipulated the things and they were caught.
You file affidavit.
Lordship, it is ready. My lord, what has happened? Unfortunate incident, my lord. One officer was coming for swearing the affidavit. He met with an accident. Now he has been hospitalized. Then another person came yesterday, last night. He'll be reaching today now from Dibrugarh.
Where is the order under tier two to the petitioner?
No, it is a composite, my lord, tier 1 and 2. Tier 1 is to bring it from the FCI go down to GPSs. Then the agreement includes that will be distributed to the doorsteps of the fair price shops. The agreement is composite. It is not, my lord, divisible. So there is a time frame. For 2 months, for May and June, for the month of May, he has not further distributed to the fair price shop. So there was an FIR also lodged against the GPSs.
Mr. Mohanto,
My
we'll have to decide your case on Tuesday. We'll give him time till today to file the affidavit.
Yes.
And we'll call for this document.
Yes.
Where is the order given to the petitioner for tier two delivery?
By the
If that order is not there, you succeed in the case.
by the GPS.
There will not be any order, my lord, for tier 2.
Yes.
because the entire contract is to deliver.
All right, then you bring on record the contract agreement. You have
It
brought
is there, it is there. Kindly see, I'll place it.
No, but we have to give them at least 2 days time to file.
True,
the affidavit.
true. That is why they were given time till today.
So I understand he's saying the officer
Yes,
met with an accident.
some inconvenience has been caused. by this.
But the other officers.
No, we
It's coming.
appreciate your client's urgency, but
Let the,
otherwise that will be the ground in appeal.
true.
Uh,
Well, otherwise also,
And my lord,
their opportunity, they got it, but they didn't avail it initially. That is the difficulty, my lord. The government.
and lordship
Get
possibly
the opportunity.
can hear the entire matter because of what he is seeking by way of.
Today I am hearing the entire matter, but no adjournment. By today you have to file the affidavit.
Well,
And we'll have it on Tuesday as a fixed item.
okay.
Tuesday or Thursday, you choose between the 2 days, Mr. Mant.
Tuesday, my lord.
Any day,
Tuesday, I am here, man. No issue, lordship.
Tuesday.
We want it on Thursday?
Tuesday, my lord.
Tuesday.
Tuesday will be with her, my lord. Beginning of the week.
All right. Heard Mr. K. Mandul as a senior counsel, assisted by Mr.
I answer.
MH.
MH answer.
Great petitioner. Also heard Mr. B.J. Talukdar, learned senior counsel, assisted by Mr. P.K. Medhi, learned counsel representing respondents who submit that the officer who was coming to Guwahati from Debrigad to swear the affidavit to be filed in this case has met with an accident and is now hospitalized. As such, his replacement is coming to Guwahati today, coming to Guwahati and will reach today. As a result of which, the affidavit on behalf of the respondents could not be filed earlier. Having regard to the controversy involved in this proceeding, this court is of the opinion that affidavit of the respondents would be of vital importance in deciding the writ petition. As such, time is granted till 12 p.m. tomorrow, that is give the date, to the respondents to bring their stand on record by serving record by filing affidavit after serving advance copy upon the petitioner's counsel. The registry will list this case again on Tuesday, date to come 26/9/2023 as a fixed item for admission hearing by tagging the affidavit, if any, filed by the official respondents.
My lord, meanwhile, lordship may say they may not go for allotment to any other.
No, you are going, don't take any precipitate action,
Yeah.
we'll immediately satisfy.
That lordship will kindly record it. Because
It will be taken care of.
we never know their modus operandi.
We'll take care of it.
Yes. Obliged.
It can't be that you succeed and get nothing. That can't be.
That's true, but then meanwhile, if third party.
We'll
comes
set
in,
it
then-
aside, as simple as that.
but
These
the
are
third
sub
party
judice
comes
matters.
in, again complications, that's why.
They can't do it.
Item 14.
Obliged.
Yes, what is this?
It's a case of religious denomination, my lord. Nalbari CC Horimandir, my lord. The lordship may kindly see the impugn order, my lord, there at page 58, my lord.
So this is fixed for admission.
Admission, my lord, for consideration of the interim order, your lordship's pass order, my lord.
What is the interim order you're seeking?
My lord, to stay of the order dated 22/7/2023, my lord. And service report, my lord, by hand we have served, my lord, almost all the.
So where is the impugn order? Page
At
number?
page 58, my lord, and it's a clue.
Page 58.
58. A meeting was held on 22nd day of July 23 in the conference hall of office of the District Commissioner Nalbari to review the function of Horimandir Committee and assessment of accounts maintained by the committee. The chairman welcomed all the members and officers of the in the meeting and it was held on 22nd day.
There's a lot of noise coming from somewhere. Mr. Saikia, please mute yourself. Yes.
My lord, at the very beginning of the meeting, Honorable Minister welcome all participants and members of Hori Mandir committee and discuss the function of present committee. After that, the Honorable Minister members to give their views and suggestions. After hearing all suggestions and after fair discussions, following decision.
Just a minute, Mr. Saikia, Mr. Devali.
Yes, Lord.
You are not on mute. I am hearing every discussion happening in your chamber. Would you please, Mr.
Glitch.
Yes, yes.
Am I audible, Lordship?
You are audible loud and clear. But till the time you make your submission, can you please mute so that otherwise the noise sound is coming to the court. Can you hear me? No, now you are on mute. Now you are on mute. Mr. Saikia, now you are on mute. Okay, yes.
As all members have given their consent, meeting has decided to dissolve the present committee from today itself, and district administration will take over charge of the Hori Mandir till the formation of new committee. The present committee henceforth stands dissolved. That it is also directed to close all the non-operational accounts operated by Hori Mandir committee in this regard.
So just a minute.
My
This
lord, committee has been dissolved, my lord.
committee was formed how?
My lord, there is a constitution of Hori Mandir, my lord. It
Yes.
was, committee was elected body. It was.
What is the term of the body?
Term of the body 3 years. It was elected in 2018, my lord.
Yes, so 3 years have lapsed.
3 years have left, my lord, during COVID, my lord. The accounts of the committee that could not be prepared. And on August 22nd, August, my lord, 22, my lord, the last.
All right, now who are you?
I am the life member of the committee, my lord. Life member of the committee, and we elect the executive committee, my lord, in our meeting, my lord,
Right,
general body meeting.
right.
So I have got my right, my lord, to challenge this order, because this order has been challenged, my lord, in violation of the Article 26B and 26D. And even, my lord,
So any member of the committee who was a part of the earlier committee has challenged this order? No.
no, my lord, what happens, my lord, in this case, earlier the president and general secretary filed one writ petition, my lord, immediately after the order, my lord, within 7 days. But the minister concerned, he requested the president and secretary that on August 12, a meeting will be held and matter will be resolved, so he withdrew the case. Then at registry level, my lord, the writ petition was withdrawn, my lord. Before it got registered, my lord. And thereafter, my lord, on August 12, meeting was held, but in that meeting, the entire my lord, persons of some political party, my lord, that appeared, and only the life members and member of the committee, my lord, they can appear in the meeting. But presence of the others, my lord, those.
So
who-
you are not personally aggrieved. It's you are espousing the cause of
I
the
am
devotees.
personally agreed, my lord. I am one of the elector, my lord. I along with the other life members, my lord, elect the executive committee, my lord. So I have got my right, my lord. Even, my lord,
No, you have your right, but you are asking for a stay of this order.
stay of this order, restoration of the committee, because.
But how can that committee be restored? It has lost its term in office as per the constitution.
My lord, until and unless the elected body is replaced by another elected body, my lord, that elected body will be decided by the, my lord, executive committee will hold a meeting.
Where is the provision? Let us see.
My lord, at page 42, my lord.
Page 42.
42, my lord. Clause 9, my lord. Procedure of election, my lord, from clause 8, my lord, I am reading.
So this is what you are reading from the constitution of the
Hori Mandir.
Yes,
The general body meeting of Hori Mandir shall elect the members to the executive committee. The general body shall appoint 3 officers consisting of election officer, assistant election officers for the purpose of conducting election. The members of the executive committee in their sitting, the office bearers shall elect the office bearers through the procedures laid down in clause 7A, B, C. Some same members can have in the event of any contest, there shall be election through ballot. The term of the executive committee shall be 3 years. In the 3 years by inviting the general body meeting in the month of August, the report of the year and accounts shall be furnished before the general body. Before completion of the last year of 3 years tenure, there shall be a constitution of the new executive committee in the said general body meeting. In case of any inconvenience to hold such general body meeting, the tenure for holding such meeting can be extended up to 6 months. Otherwise, 1/3 of the life members and general members will be able to submit an application for requisition meeting before the president and general secretary. Here in this case, no requisition meeting was requisition by the members, because on August 22 terms expired and due to COVID-19, the accounts could not be.
so if the earlier term of the earlier executive committee
Yes,
has
that
expired,
is expired.
the whole election and elect a new executive committee.
A
has
new
to-
election, our prayer in the writ petition, my prayer is the writ petition, that this elected body cannot be dissolved by the district commissioner, the general body will, the executive committee will hold a meeting and it is under process, Executive committee will hold a meeting and thereafter the new executive committee will come and to replace us,
So date of election has been notified.
not notified, In the meantime, this order has been passed, on 22nd,
No, Mr. Chaudhary, you see, this is going to be the clinching issue in your case. If one of the members of the executive committee would have come,
Yes, my lord.
then the matter would have
I
been,
have made entire executive committee member as party to the party respondents in this case, so that the matter can be decided in their presence. And
you are not understanding the point. Please listen to the question.
yes,
After that, you are entitled to give whatever reply you want.
yes,
I am telling you that essentially the grievances that the executive committee has been wrongly dissolved,
yes,
correct?
yes,
So if that happens, the primary grievance has to be with the members of the executive committee, is it not? They are the ones who are suffering. You
Sir.
may be indirectly interested in the matter, that is another matter.
yes,
But it is the members of the executive
But-
committee
yes.
who have been thrown out of office.
yes.
They are not aggrieved.
They first came before this
No,
court.
that will not take
Yes.
place. They
Malad,
came- What
I-
happened behind the
I
scene? we are
am
not
member, I am one of the persons to elect the executive committee.
So correct, therefore
So,
we are asking
yeah.
you, the term of the earlier executive committee has expired.
Yes, madam.
You have a right to elect. So
Yes.
we look into what is the election schedule and when the election.
I have prayed for this, Melody. The power has been given by the constitution to hold the general meeting for election of the new
Who
body.
will hold it? Who will hold it?
The general body elected, the general body, Melody,
Hmm.
which has been dissolved, Melody. The general body that cannot be dissolved by the district commissioner, Melody.
General body has not been dissolved.
Executive committee, Melody. Executive committee that cannot be dissolved by the district commissioner, Melody. The executive committee will hold a meeting, general body meeting. Since new general body meeting has not been
So
held. by
therefore
new
you hold
committee-
the meeting. What is the procedure for holding general body meeting? You hold it.
Yes, sir, we will hold, Melody.
Yes, you hold the meeting and decide on the election and go ahead.
Yes, Melody, but there are subsequent some development after 22nd of July, Melody.
Hmm.
Lot of committee has been formed, Melody, have been formed by the district commissioner. Melody, all these committees, I have my prayer in this petition, Melody, this should be declared illegal, Melody, because they cannot constitute any committee. Even, Melody, I want to cite the judgment, Melody, in this regard. मतलब the
Hmm.
year 1954 Supreme Court, page 282, मतलब. Paragraph 22.
Acha, who are the members of this committee now? The committee, who are the members? The new committee constituted by 27/7/2023.
मतलब the general, only general secretary, he was made a member in the newly constituted committee, मतलब.
Hmm.
And that general secretary, earlier general secretary, मतलब the dissolved committee general secretary, he has resigned on 14/9, protesting that the district commissioner has no authority. मतलब I am
That you may be right. I am asking you,
Yes.
who are the members of this committee now?
bottom at present, मतलब. At present, मतलब I have,
Yes, yes, bottom one, yes.
yes, I am sorry, मतलब.
That is more emphatic than at present. Hmm.
At present, मतलब there are
Mr. Datta, is there any
Only-
bar in hearing arguments in the vernacular in a high court?
No, not at all. Well, some of the high courts, as your lordships knows that Allahabad High Court, almost they speak Hindi.
Then why not in Assamese in
Yes,
Guwahati?
मतलब
If your lordship encourage, we can start.
in mother.
If there is no bar, please tell us.
I don't
Because
think
you
that,
see, that takes away a lot of pressure from the councils.
yes.
Because formulating an argument in Assamese or in own language, then
It will have to
translating
be
into English,
thinking in Assamese and it have
it
to be
takes away a
translated.
lot of sheen from the argument.
That's true.
So
It may
unless
be-
the judge has any inconvenience.
Yes. It may be made optional, madam,
No,
because
but why is it that only English arguments are heard in Guwahati High Court? In the principal seat?
Melody in almost in Calcutta High Court also, they speak in English, not in Bengali.
No, but why is it?
Lordship, there is a constitutional provision,
Acha, what-
Article 348.
Just let me see, just a minute. Sir.
Language will be 348.
Even sometimes, my lord, when his lordship Sudhanshu Dhulia was here, we started in arguing
Hindi.
Hindi also.
Language to be used in Supreme Court and in High Courts and for action bills in English language. 348.
But 348(2) has a provision.
There is a provision, but that is not there till now.
Perhaps there is no request.
So maybe, Lordship.
It will come in the necessity, my lord.
Sorry,
It will come in the necessity in future, my lord.
let us see when it comes.
My lord,
All right.
my lord, I cite the decision, my lord, year 1954 Supreme Court, page 282, my lord. 82. Paragraph 22, my lord, it has been made clear by the apex court, my lord, here in respect to it squarely covers my case, my lord.
Yes.
I am reading, my lord, the entire paragraph.
Who was the petitioner in that case?
My lord, Sidur, my lord, here, my lord, Commissioner Hindu Religious Endowments, Madras.
Yes, what is the decision?
I am giving a copy, my lord. Even this decision has been used, my lord, relied on in Sabrimala's case, my lord. Paragraph 22, my lord.
Yes.
It is to be noted that both the American as well as in the Australian Constitution, the right to freedom of religion has been declared in unrestricted terms without any limitation whatsoever. Limitation, therefore, have been introduced by courts of law in these countries on grounds of morality, order, and social protection. and adjustment of the competent demands of the interest of government and constitutional liberties is always a delicate and difficult task, and that is why we find difference of judicial opinion to such an extent in cases decided by the American courts where question of religious freedom were involved. Our constitution makers, however, have embodied the limitations which have been evolved by judicial pronouncements in America or Australia in the Constitution itself, and the language of Articles 25 and 26 is sufficiently clear to enable us to determine without the aid of foreign authorities as to what matters come within the purview of religion and what to do, what do not. As we have already indicated, freedom of religion in our constitution is not confined to religious belief only. It extends to religious practice as well subject to the restrictions which the constitution itself has laid down. Under Article 26B, therefore, a religious denomination or organization enjoy complete autonomy in the matter of deciding as to what rites and ceremonies are essential according to the tenets of the religion they hold, and no outside authority has any jurisdiction to interfere with their decisions in such matters. Of course, the scale of expenses to be incurred in connection with these religious observances would be a matter of administration of property belonging to the religious denomination and can be controlled by secular authorities in accordance with any law laid down by the competent legislature. But here in Assam, there is no legislation except Religious Endowment Act. For it could not be the injunction of any
So
religion.
is there any
Yes, sir.
priest or doloi in that temple?
No dollar, Malay.
No doloi.
No dollar.
Who is the head priest?
Malay,
Of course, the elected member cannot be the head priest.
Malay,
This committee is for managing the
managing
non-secular part.
for administration of the religious
Yes,
matter.
this is for administration and management of the
Management
temple
of the
trust.
religious, yes, sir.
But the elected bodies are not the priests. They don't
No,
perform the
not
religion.
priest, Malay.
Who are the people who decide on the,
There are the appointed priests, Malay.
who are the priests today?
I am not aware of it.
Oh, that will be
Malay,
very.
they are in the Hari Mandir committee, Malay, has been observing puja, etc. Malay. From Vishwakarma puja, I have stated in my petition. The Ras puja is the
Mr. Chaudhary,
Ras puja is the main
we are
puja.
trying to come to the point.
Malay, I may be allowed to complete the entire paragraph, Malay.
Alright.
Then I will argue on that point also. Malay, how a committee cannot be from one committee to other committee, it cannot be handed over. This is the law, Malay. Of course, the scale of expenses to be incurred in connection with the religious observances would be a matter of administration of property belonging to the religious denomination and can be controlled by secular authorities in accordance with any law laid down by the competent legislature. For it could not be the injunction of any religion to destroy the institution and its endowments by incurring wasteful expenditure or rites and ceremonies. It should be noticed, however, that under Article 26D, it is the fundamental right of a religious denomination or its representative to administer its properties in accordance with law. And the law, therefore, must leave the right of administration to the religious denomination itself, subject to such restrictions and regulations as it might choose to impose. A law which takes away the right of administration from the hands of a religious denomination altogether and vests it in any other authority would amount to violation of a fundamental right guaranteed under Clause D of Article 26. So, the administrative body is the executive committee, and here the district commissioner has sought to face the power which another committee. This is illegal, it affects the fundamental right of the denomination. Even that This judgment has been relied on in subliminal case also, my lord. In paragraph 152, this decision has been relied on, my lord. And apart from this, my lord, the management of the accounts, etc., and property that has been taken over by the deputy commissioner. So I refer section 22, my lord, of the Religious Endowment Act 1863. In our state, my lord, there is no other regulating act, my lord, in respect of it. And section 23 to 22, I am reading, my lord,
You are reading from?
Religious Endowment Act 1863, my lord.
Is it a part of the petition?
My lord,
Given the book list? No.
book list, your lordship may perish, my lord.
Then what
It-
will you
it
read?
Completely bars, my lord, the jurisdiction of the government, my lord, so far taking over the management of the property.
So is there any endowment for the Hari Mandir? There is government,
My lord,
this act is Religious Endowment Act.
religious endowment, ma'am, my lord, there is the definition part, my lord, my lord, if customarily one follows, my lord, the puja archana, everything, my lord, the religious act, my lord, in respect of Hindu, my lord, then it becomes an idol, my lord. That has been discussed in this judgment itself, my lord, in Sutima case, my lord. So it becomes, it's an old institution, my lord. It was established in 1933. And since 1978, my lord, this constitution is prevailing, my lord.
Minister, who is the minister in this?
Minister, my lord, Jayant Amalla Borua, my lord, the Public Health Engineering Department, my lord. He is minister of,
That is his constituency.
yes, my lord, he is MLA of that. And in my client and earlier client, my lord, Ashok Sharma, he was also MLA, former MLA of Nalbari. And he is the president of this body, my lord, who is aggrieved now. The main tussle in between these two persons, my lord, and the body, idol is affected, my lord.
And where is the new committee, constitution of the new committee? The ad hoc committee or whatever you call it?
Ad hoc committee, my lord, I have not
Hmm?
I have not made any statement, my lord, because I do not know about it, my lord.
No,
Because
but presently, who is running the affairs of the temple?
district commissioner, my lord, district commissioner appointed a committee.
Where is
and
that committee? Where is the appointment of that committee?
that from my knowledge, my lord, one Manoj Kumar Soudri, he was earlier general secretary, he was one assistant secretary, and he is now there.
No,
And
Mr. Chaudhary, you see, your grievance is that the existing committee was dissolved.
yes, my lord.
And the
And-
second limb is the district commissioner has constituted a own committee,
Yes,
which is now running the affairs of the
yes, at present.
now.
This,
See, the earlier committee being dissolved
yes,
is one matter that the court will see whether that committee in any case had any right to stay in office.
yes, whether this,
Please, because otherwise what will happen, you will make your submission, I'll write my order. If you
Sorry.
want that, it can be
sorry,
done.
my lord.
The earlier committee in any case had lost its term in office, which was 3 years, on the day on which this impugned order was issued, 27/7/2023. So whether the minister could have taken part in his individual capacity in the meeting or not is another matter. He was identified as minister, but he can always take part in a meeting of the committee as a devotee.
Yes,
But the fact remains that the earlier committee had lost its term in office. That committee obviously will not be restored in this writ
my
petition.
lord, that,
Acha, you continue.
my lord, my submission that
You make your submission.
as per the, I am not interfering your.
No, you are not interfering. You are not even trying to
Only-
understand what is the
My lord,
problem.
I have
before
followed,
you.
my lord, I have followed, my
You
lord.
don't even understand what is the problem. What will you argue?
3 years.
You have not challenged the order which you are aggrieved with. That's what I'm saying. I dictate the order. and filed in it.
I have silenced the order.
Where is the order constituting the new committee? That's
New-
what I'm saying.
New committee has not yet been constituted, my lord.
Oh, dissolution, that committee cannot be restored. That's my.
New committee has to be constituted by the general body, my lord. That is
Do it. Let
called
the general body do it.
general body, that is called by the earlier, the existing committee, my lord.
So where is the committee constituted by the deputy commissioner? The district commissioner is constituted a committee,
Yes,
is it?
my lord.
Where is that?
My lord, by the order 22/7/2023,
Hmm.
here it is not mentioned regarding committee, my lord.
Then from where are you saying that?
My lord, at present, the idol is running, my lord. So that is why I have said that district commissioner is operating everything.
That is your
Yes.
perception. Where is the order? If there is an order, you show it,
My lord,
then we'll examine the
had
validity. of
had
it.
there been order, publicity of the order, my lord, had it been published, then certainly I would have got, my lord. How can I impugn that order, my lord? I have impugned the main order. Whether your lordship would decide the matter, whether the district commissioner has jurisdiction over it.
No,
or
no,
not.
district commissioner did not do it. It was
Dis-
done by the
No, my lord.
members,
District,
members.
it is the order of the district commissioner, my lord.
That's right, he has notified it.
My lord, even the committee allows, my lord, if statutorily the district commissioner is barred, my lord, to interfere with the matter of idol, in violation of Article 26, how can the district administration can take over the management of the property, my lord?
No.
That is the question, my lord. How can he, my lord, how can the district commissioner can extend his jurisdiction to that extent, my lord? Even he is requested, my lord, he cannot do, my lord. If something is illegal, my lord, and somebody else request the deputy commissioner
Why
to
is
do the
the
illegal.
committee not taking step? Why is the general body not taking steps to hold the meeting for election of new executive committee?
It is their own matter, my lord. That can be, if any person is aggrieved, my lord, then your lordship may kindly say section
Why
14.
is your client not taking?
Section 14 of the Religious Endowment Act itself says, if any person aggrieved, my lord, then he can go to the civil court, my lord. Then, but no, it is the jurisdiction of the civil court, my lord. Your lordship aware of the Kamakya dispute, my lord, Kamakya temple's dispute. There are two committees, my lord, and one committee went to the civil court, but the civil court jurisdiction has been taken over by the civil administration. That is government, and government, statutorily the government is barred from taking over the property. This is the case before your lordship, my lord. How the district commissioner can extend jurisdiction, my lord? He has abused his office, my lord. Completely.
All right. Anything else?
My lord, same judgment, my lord, in Sabrimala's case also, my lord, it has been relied on, my lord. This is my humble submission, my lord. I want to say this, and my prayer before your lordship that the general body should be allowed to be held. General body meeting.
Who is stopping? Who is stopping you from holding
My
the
lord,
general body?
My
We
lord,
can understand
since
if
the
you,
committee has been dissolved, my lord, that is why, my lord, a district commissioner has taken initiative, my lord. He is in front of him. I was beaten up, my lord, while I protested, my lord. Then
that is
who will dare, my lord, to hold a meeting, my lord, at the violating the order of the district commissioner, my lord. So district commissioner may be directed to give, my lord, proper security, my lord. The earlier executive committee that will take over the entire search, my lord, and they will hold the general body meeting within time frame, my lord, and thereafter, my lord, the new committee will take over the search.
yes, Mr. Sekhya, Advocate General.
Yes, Lordship.
Please.
I have 3-4 rounds of limbs of our argument. The first one is that maintainability point, whether the writ petitioner has locus standi.
हमको भी पाई निकालो ना।
Am I too loud, Lordship?
Mr. Sekhya,
Lordship,
let me ask you one question.
Lordship.
Prima facie, what I find is that the deputy commissioner has notified the dissolution of the earlier executive committee
Yes.
on the grounds mentioned in the order, and it appears that it was done with the consent of all the members.
Lordship.
Now, it is not that another committee has been constituted by the deputy commissioner, that there is no document to show that.
Lordship.
Assuming that the dissolution was in accordance with law, or that the
Lord.
deputy commissioner had the jurisdiction or authority to do it, even then, under the constitution of the Mandir committee, now steps have to be taken for constituting a new committee.
Lordship.
What do you have to say on that? Let's first hear on that.
Uh,
Why should
ini-
the court call
ini-
these issues?
Yes, initially a date was fixed to 23rd September to be the date for election. Now a fresh schedule has been announced. According to that, the 30th October, the election will take place. Already the officers to conduct the elections, everybody is nominated. Voter list, all details are there in our affidavit, Lordship will find that. But
Okay.
the whole
in the
schedule is
meantime-
given, whole election schedule has been given.
And in the meantime, who is running the affairs of the temple?
The main part is run by an ad hoc committee constituted by 3 persons, and the former
No, your sound is gone.
executive committee's general secretary is a part of that committee.
Where is that ad hoc
He
committee?
has resigned, my lord, already.
Where is that ad hoc committee? Where is that
Ad
committee?
hoc committee, Lordship, in our affidavit, Lordship will find. Lordship will kindly take the affidavit, the minutes of that meeting of 12/8 meeting. If Lordship is pleased to take my affidavit,
Yes.
it will start. I'll just on second, Lordship. Yes, page 99. They have suppressed the most material facts. There are 2 important meetings, one meeting in the month of
Just a
May.
minute, just a minute. Is the affidavit on record? Where is the?
It may be in record, Lordship.
This is the one. Just now it is coming. All right. Which page you are referring to, Mr. Sekia?
I am referring to page 99, that is a translated copy. The main Assamese vernacular copy is also annexed
Yes.
at page 106. A special general body meeting was held on 12th of, and it was convened by the executive committee persons of the erstwhile EC.
Hmm.
May I read it, Lordship?
Yes, please.
Actually, Lordship, before coming to 12/8, Lordship, I would like to place what happened in the month of May and June, because
Yes.
they are suppressing the most vital facts before this honorable court. And on that ground, the writ petition is liable to be dismissed. The first meeting held 14/5, that Lordship will find at page 82, Annexure 1. Minutes of the meeting of 89th Nalbari Rakh Mahotsav under Sri Hari Mandir, Nalbari, held on 14/5/2023 at 4 p.m. This committee is a part of the Hari Mandir committee. This is a major committee. My learned senior friend also said that Rakh is the main festival there. So this committee has a lot of importance because this is the flagship event of this Hari Mandir committee. The meeting of 89 Nalbari Rakh Mahotsav under Sri Hari Mandir committee held on 14/5. The meeting was presided over by so-and-so. He was invited by them, and he was, before that, Lordship will kindly come to paragraph 9. Paragraph 9 of the affidavit of the writ petition. Paragraph 9.
Mr. Just a minute. Mr. Chaudhary, have you received this affidavit?
Yes.
You don't want to file any rejoinder?
Yesterday.
My lord, here is, my lord, only.
No, don't start argument. If you don't file any rejoinder, I will go by what they're saying is correct and as admitted.
My lord,
So that is the
today-
risk you will run.
Today is the day for consideration of the interim order, my lord.
Hmm.
I will file rejoinder, my lord. I will file a reply of it, my lord, during the course of hearing, my lord.
During the course of hearing, how it can be?
My lord, if hearing is taken place, my lord, I argued the case, my lord, only for interim order, my lord.
Hmm. So
Because,
then let me pass an order on the interim order.
yes, my lord,
Yes. Then you want to file rejoinder?
yes, my lord.
How much time you want?
My lord, 1 week, my lord.
Do you really want an order on the interim order? Then I will not give 1 week. If it is rejected, it will go up to 4 weeks. Or if you want to file a rejoinder, I can post it next week. next Thursday. You decide.
my
You
lord,
can have it both ways.
my lord.
If your only argument today is for interim order,
Yes, my lord, interim order,
then either the interim order will be passed or it will be rejected. If it
Yes.
is rejected, then the matter is going back by 4 weeks. That is after puja holidays. If you want to file rejoinder next week and then interim order to be argued, I can give you that. You can have it both ways.
my lord, I have submitted already, my lord. Regarding the jurisdiction of the deputy commissioner, my lord. I have cited the judgment of the apex court also, my lord. A violation of article 26B, my lord. Regarding a right of administration by the committee, my lord.
When is the Rakh?
My lord,
When is the Rakh festival?
Ras festival, that will be in November, my lord.
30th October is the date of election, and lordship, lot of submission has been made regarding Article 26.
Election.
What is Article 26? Let us read it, lordship, first. What is
Election, my
Article
lord.
26?
Yes, I am reading, my lord.
I am reading. This is my turn now.
No, Mr.
Lordship,
Chaudhary, that's okay. You take your seat.
Yes.
I only wanted to know.
My lord,
whether-
my submission is in respect of the interim order, my lord.
Okay, so Mr.
Because otherwise, my lord, your lordship may see, kindly see the order earlier passed, my lord. Your lordship passed that order for consideration of the interim order, my lord.
Yes.
On that day,
Mr. Saika, I'm not inclined to pass an interim order. We'll fix it
Lord.
after puja vacation. He has declined,
Lord.
he has declined the offer.
Lordship,
He
lordship,
submit
I am highly
rejoinder.
obliged.
no,
All
my
right.
lord,
Highly obliged, lordship.
I will submit the rejoinder, my lord. My lord, your lordship may pass a order as in respect of interim prayer, my lord.
All right.
That is my.
Heard Mr. D.
Can I take 5 minutes time of your lordship?
Yes.
I'm for some of the executive members. Now, my lord, the first question here, if your lordship look at the order passed by the landed DC. My lord, if the exercise of power comes, if the power exists in law, now my lord, how he is exercising this power? Under what provisions of law? Can anybody locate under what provision law if he has passed?
What
this order?
happens if this order is set aside? Who is going to take over?
My lord, the question is whether he can dissolve the earlier body, what right he has, what power he has.
That we have,
Can
to,
anybody locate under what provision law he has passed this order?
that we have to hear after the.
Therefore, my lord, even if your lordship sees that Nadir Shah's case, that if any power is given, that power will have to be exercised in that manner or not at all. Now here your lordship will find there is no provisions of law to pass this order. Now
That's
going
the
to-
question I'm asking. That is, if you are ready for final hearing today, then argue. I'm ready to hear.
My lord, only thing you are. your
This
lordship-
question cannot be answered for interim order.
That's a very
The,
correct.
the-
my
the
lord,
reason is why I will decline the interim order is the body which has been dissolved in any case had lost its term in office.
Your lordship is very correct.
So
But
therefore,
then-
the question
then-
of restoration does not.
Yes,
arise.
the next question would be,
I had given that
whether-
offer to Mr. Chaudhary. He has declined it.
My lord.
Now I have disclosed my mind. I am not.
Yesterday at 4:30 PM, my lord,
I have given you that offer, whether you want to file a rejoinder and fix it on.
Certainly, my
Thursday.
lord, I
Declined it,
will file rejoinder, my lord.
but interim order, I'll pass the order now. That I have disclosed my mind. I cannot do it. The earlier board cannot be restored.
Only-
It has lost its term.
Then, 1 week time may be granted, my lord. I will file rejoinder, my lord.
Yes, no, I'll not do it now. Now I've disclosed my mind. Heard Mr. D. Chaudhary, learned counsel appearing for the writ petitioner, also heard Mr. D. say, you should have taken that opportunity, Mr. Chaudhary. These are contested
Malad,
legal matters.
My lord,
We will go by established principles.
we are also emotionally involved in this case,
No,
my
no,
lord.
we can't- we
Because
can't do
Hori Mandir is a very 90 years old institution, my lord. 90 years old institution, my lord.
that.
The
No, Then
constitutional.
you are
body-
trying to get the judge emotionally involved. or
No,
something
my
like
lord.
that?
I
Then
am certainly not, my lord.
We have to go
But,
by the law. How can a
yes, sir.
committee
I have.
which has lost its force?
I have cited the judgment regarding jurisdiction, regarding article 26. My lord, of course, my lord, these will be
These are matters will be gone into. But interim order would mean restoring a committee which has already lost
But
its term.
if your lordship decides the interim order and if it is rejected and posted after 4 weeks, my lord, that will be.
I don't know. I recorded in the judgment that when this offer was made, you declined it.
My lord, I will file rejoinder within 7 days, my lord, and it may be posted, my lord, thereafter.
But not before this court. After I have disclosed my mind, I will.
Lordship, my humble submission,
Yes.
let them file affidavit and the whole matter may be fixed for disposal on 4th of October if they so want.
Yes, my lord,
Right.
I have no. Port of.
All right, note it down.
If the disease order goes that way, my lord, there will be complete anarchy. We don't understand that
And,
where we are staying in a democratic land or not.
If the disease order,
If his order persists,
Hmm.
my lord, there is no law that he can pass that order.
that is your submission, Mr.
My lord,
Doctor?
I have not opened my submissions.
my lord, the Supreme Court, the constitutional bench has said, if there is a law exists, you can pass that order. If there is a
Mr.
law.
Datta, I am just asking a simple question. You are supporting, it appears there is a
Yes,
collusion
yes,
here.
Yes,
My lord,
Are you ready for final hearing today?
my lord, I think we shall have to counter that. the
Then you
affidavit
counter
filed.
it, you are
So
making an argument, and when the court is not
My lord, I'm sorry
floating
for
with you,
that.
then you are asking
No,
for.
I'm sorry
adjournment.
for that, your lordship.
This
Give
is
us
not the
1 week time
way.
and fix it on 4th as learned advocate general has said.
On the request of Mr. D. Chaudhary, learned counsel for the writ petitioner, this matter, now you write like this. The respondent number 2, 3, 4, and 5 have filed counter affidavit opposing the prayer made in the writ petition. Yesterday, a copy of which is available on record. Mr. Chaudhary submits that a week's time is required for him to file rejoinder affidavit. First up, Mr. D. Seika, learned AG Assam, is present on behalf of the respondent numbers 1, 2, 3, 4, and 5.
1, 2,
1 to
5.
4. And Mr. S. Datta, learned senior counsel, assisted by Mr. S. Datta, has appeared on behalf of respondent numbers. Mr. Datta,
My lord,
respondent numbers.
I'll be giving it to my lord, my stenographer. There are so many. My lord, the 9, 10, 12, 13,
9, 10, 12, 13,
14, then 15 to 19,
14, and 15 to 19.
then
Where-
21, 22, 23,
It's a long list.
27 and 28. My lord, I'll assist him.
All right. What about the other respondents, Mr. Chaudhary?
My lord, we have filed affidavit, justice service was allowed, my lord, we have served copies and filed affidavit, my lord. So for respondent number 7, 8, 11, 20.
Mr. P. Nayak, learned counsel, has appeared, has entered appearance on behalf of such respondent.
8, 11, 20.
And Mr. B. Chaudhary, learned counsel, has appeared for respondent number 6. First up. The service is complete in that.
Yes,
As such, service of notice is deemed to be complete in this case. In view of the prayer made by the petitioner's counsel seeking a week's time to file rejoinder, registry is directed to list the matter again on 4th of.
Lordship, could it be on 9th of October? Lordship, 4th, I'm just sorry, Lordship, I'm changing my date. Could it be on 9th? 9th, that is Monday. What final disposal, admission hearing, Lordship?
my lord, at least my submission will be, my lord, no further their my lord, proceeding regarding this.
That order will pass. No major decision.
Yes.
No, Lordship, Lordship, one thing, in that case, Lordship, I have to make a submission. The election process has already started.
That will.
That will go on. That will go on.
That
And
will-
so far as regular activities in the Mandir, Lordship, that
Our-
is also allowed to be conducted by the erstwhile General Secretary.
Election process, my lord, our case is that that election process cannot.
That
be
election process they
another
do
body,
not
my
want
lord.
to have.
Another, by not another body, my lord.
No, election process will go on. And
It will go on.
regular affairs of the temple will also be.
That is also given, Lordship, charge to the
If election
former
process-
secretary.
This is written in the order, my lord, then it will be, my lord, they will think it that this is justification to them to proceed, my lord. My lord, the election process that can be done only through the constitution, my lord. That constitution, as per constitution, my lord, the earlier body has the right. That is the case, my lord.
Lordship, I would like to make my submissions then. If they have so much to say, the tenure was over in January 2022. They were elected in 1980.
Mr. Saikia,
Lordship,
to be very honest, it's very uncomfortable for me to hear lengthy arguments to VC. Because so we'll have it on next Thursday.
Lordship,
Available on next Thursday?
Lordship, I'll be available next Thursday. Just 1 second, Lordship. Let it be on next Thursday. I have my rituals, Lordship. That is
All right.
Thursday and Wednesday.
When is the earliest you will be available?
Lordship, earliest is 4th of October, Lordship.
Then let us have it on 4th and then we'll
Yes,
see.
Lordship. I'm highly obliged.
All right.
Let it be on 4th.
Yes, because you see, there's some problem with the acoustics in the VC. It's very, very uncomfortable to hear lengthy.
Lordship,
We'll have it on 4th then.
Lordship.
Let this matter be listed again on 4th of October as a fixed item for admission hearing. The prayer for interim order shall be considered on that day.
Lordship, highly obliged.
Obliged.
Daily list, final disposal and admission because item 4.
My lord, in this matter, I have received the records just now, my lord. Can it be at 2 p.m., my lord? Let me go through the record.
What is the matter about?
My lord, about the land acquisition, my lord, because as per your lordship direction, last time, my lord, the land which was 1 kata 7 lasas has been acquired by the 1 kata 7 lasas, which is acquired by the deputy commissioner.
Then we'll have it on Wednesday. You go through the record properly. Yes,
Wednesday or Tuesday? Next Tuesday.
Tuesday is becoming more heavier than Wednesday.
My lord, as your lordship.
Everybody wants on Tuesday. Had Mr. K. Bhattacharya and counsel for the writ petitioner, also heard Ms. M. Burman, learned government advocate Assam, who submits that she has received the relevant records
Today,
only this morning, and therefore we granted 3 days time to go through the same. Mr. B.K. Singh, learned standing council FCI, as well as Ms. N. Bordoloi, learned SC Revenue Department Assam, are present on behalf of the respective official respondent. In view of the prayer made by Ms. Burman, let this matter be listed again on give Wednesday day, 27/9/2029 for admission as a fixed item.
Obliged.
For hearing, item 5 and 6.
may please your lordship.
Yes.
Lordship, in this case, what happened, lordship? Initially, land was allotted to, annual patta was issued to me, lordship. And that is annexure 1, lordship, kindly produce annexure 1, page 16, lordship. And thereafter, lordship, periodic patta was issued to me, lordship. And after 10 years, lordship, that my allotment, that land was allotted to APDCL, lordship. I have challenged that order, lordship. Lordship, kindly produce annexure 1, page 16 first, lordship.
Annexure 1,
Page 16, lordship. That is, my proposal was sent by the additional deputy commissioner to the circle officer, lordship, for issuing of annual patta, lordship, as approved by the deputy commissioner. This is to inform you that the proposal submitted by your number above has been approved by the DC. You may prepare the annual patta according to the name of following beneficiaries and submit the same for signature, etc. List of the person, trace map, chitta in duplicate along with the revenue paying receipt and applicants in originals are returned herewith for favor of necessary action. That was additional deputy commissioner sent to the circle officer.
no, what is the 16th April order by means of which what is being sought to be done?
Lordship,
What is the purport of this order?
for issuing annual patta, lordship,
Annual patta in whose favor?
in my favor. My name is serial number 3, lordship, Kateki Soikia, lordship.
Serial number 3.
3, lordship, name of person.
Yes. Then what has happened?
Thereafter, lordship, next annexure, lordship, page 17, lordship, annual patta was issued, lordship.
Yes, that was in 2001.
On, lordship.
Yes.
Then, lordship, next annexure, page 18, lordship.
Hmm.
This is the certificate, lordship, issued by the circle officer, lordship.
that is issued in the year 2006, certified that the land measuring so and so, AP number 52, annual patta number 52 have been converted into periodic patta by this office order number 305/2002. And accordingly, necessary record correction is also done. Now, land number so and so stand in the name of Srimati Ketoki Soike of so and so.
Yes.
Thereafter, Lordship, record was corrected, Lordship. Next page 19, Lordship.
Hmm.
I have paid premium, Lordship. Required premium as assessed by the authority, and record was corrected. Page 19. Vernacular is also there, Lordship, page 20. In pursuance to the order dated 6/4/2022 by the Circle Officer Revenue Board, the premium has been deposited by book number so and so, receipt number so and so. Therefore, this patta has been made periodic patta.
All right.
So thereafter, Lordship, annexure 6, page 22, Lordship.
Hmm.
This is the impugn order, Lordship. May I read, Lordship, this order? Report furnished by Circle Officer Golaghat may kindly be seen. It is found that settlement of government land covered by Gulampatti village under Mokwa Moja was done in an irregular manner. Irregularities are: AP was issued directly to the LOT without prior approval to the government. Gulampatti village is in border of Golaghat Municipal Town and within Golaghat Development Authority, where no settlement is admissible without realization of premium. As per Land Policy 1989, issued of allotment certificate in initial stage is a must, which was not followed in the present case. Notice to the illegal settlement holders were issued. Under the above grounds, the settlement of 2 biga 1 kata 17 lesser government land under dark number so and so earmarked for 32/11 kV subsection under Golaghat Electrical Division APDCL Golaghat, put up for kind appeal. So this is the impugn order. Lordship, I have challenged this order.
This order was passed after hearing you.
No, that is my case, Lordship. In fact, Lordship, kindly see that Ketiki Soikia was died in the year 2000, Lordship, 10, Lordship. That is annexure 5, page 21, Lordship. No notice was issued to me, Lordship.
How this order could have been passed without hearing the
Lordship, in our affidavit, Lordship has stated that she was heard.
heard when? Which date? It is not reflected in the order.
In paragraph 13, about affidavit in opposition,
Hmm.
filed by the aspirant number 2 and 3.
Yes.
With regard to the statement made in paragraph 22, the institution entering upon basis stated before cancelling the patta of land of so and so, inquired the matter and gave opportunity to let so and so for hearing as per the principle of natural justice.
Hmm. So where, show me the records in support of this statement. You have the records. Otherwise, the order will go on this ground only. Para 13 is from what? Knowledge or record? So this statement has been sworn as from knowledge. So then he has to come. The deponent has to come.
Record.
No, he has to come. It is from his personal knowledge. There is no record. Mr. Sharma, please see page 7 of the affidavit.
Yes, affidavit 7.
No. Yes, Lordship, it's from knowledge. I have seen it. I have seen Lordship one notice issued to this business like the next case.
Next case notice was issued, Lordship, but no date was given in the notice, Lordship. For appearance, Lordship. I have annexed that notice also, Lordship, in next.
No, no, Mr. Sharma, the affidavit says she was heard. There must be some record. Where is the record?
Record is not available with us. If your lordship allows us, we can produce the record.
So there is an interim order.
Yes, Lordship.
All right. Heard Ms. P. Bhattacharjee, learned counsel appearing for the writ petitioner. Also heard Mr. H. Sharma, learned additional senior government advocate Assam, as well as Ms. G. Hazarika, learned standing counsel revenue and disaster management department, appearing for the official respondents. Post of B. Chaudhary, learned SC APDCL is present. On behalf of the respond numbers 4 and 5. The order dated 29/3/2000, what is the date? 9/1/2012, passed by the additional deputy commissioner, bracket revenue, bracket close, Golaghat, cancelling the settlement of land made in favor of the petitioner has been put under challenge entirely on the ground that the order was passed behind the back of the petitioner without giving back of the settlement order without giving an opportunity of being heard. Full stop. Mr. Sharma has, however, invited the attention of this court to statements made in para 13, which goes to show that the original settlement holder, namely late Keteki Saikya, was given an opportunity of being heard in the matter. First up, however, the statement made in para 13 has been shown as one made from knowledge of the deponent. First up, situated thus, Mr. Sharma seeks 4 weeks time to verify and produce records, if any, in support of averments made in para 13, failing which this court will have to direct the deponent to appear personally to answer the queries of this court. First up, since the primary ground of challenge made to the impugned order is on account of violation of principles of natural justice, this said aspect of the matter assumes great significance in this case and will have to be dealt with in accordance with law. Facilitating the above, let this writ petition be listed again after 6 weeks so as to enable the learned government advocate Assam to obtain necessary instruction of the record.
Let it be kept as a part head, lordship, as it's a part head matter, lordship, not submit. Next item is also same, lordship.
Same. 5, 6.
Along with item 6. Yes.
Technique is it? Lordship.
Item 7.
Pleasure, Lordship. This matter relates to the enforcement of government and in Lakhimpur district by the private respondent, Lordship. And the deputy commissioner of the Lakhimpur district, they have filed an affidavit. I have received copy in 2013, Lordship, 9/9/2013.
Matter relates to encroachment of
Government land by the private respondent. Lordship. The petitioners are erosion affected person of Lakhimpur district. Earlier, they were allowed to, due to devastating flood happened in 1998, Lordship, the erosion were happened.
No, but who are you?
Lordship, I am the erosion affected person. I was also allowed, not allotted, allowed to temporarily settle in that area in question, Lordship. But after that, we were
Right, so how are you concerned whether private respondents are encroachers on government land? It is for the government to take action against them.
yes, Lordship.
What is the relief you are seeking here? How can you ask government to take action again? It is for them to decide.
No,
How are you concerned?
Lordship, I am also praying for land as erosion affected person, Lordship. That is
That they will consider, but you can't ask the court to issue a writ to direct government to evict somebody else.
Yes,
That kind
Lordship,
of
but
prayer
in
is
their
not
affidavit,
permissible.
They had admitted that lands are enforced by the private respondents. Lordship, which were-
Maybe, so let them go ahead.
Lordship.
You go ahead as per law. How can the writ court issue a direction?
My lord, in fact, these lands were allotted to somebody's name. But
Mr.
they are-
Talukdar, that is not the point. Point is the writ court will not issue a direction that evicts so and
That I
so.
understand.
That is not the mandate of law.
He has no.
The courts are to protect the interest of people, not to,
He has no Lucas.
that is for you. In 5 minutes, you decide what you want. Mr. Saiwala, you want for whom? Private respondent.
When the advisory committee has cleared.
That's the reason. Writ court can't.
Notification. Lordship. 6th of January.
So you apply and they will consider according to. Heard Miss M. Devi,
Bora, Lordship.
M. Boral and counsel appearing for the writ petitioners. Also heard Mr. B.J. Talukdar, learned senior counsel assisted by Ms. N. Bodoloi, learned SC Revenue and Disaster Management Department, Assam, appearing for the respond numbers
1, 2, 3, 4, and 5.
1 to 5.
1 to 5.
Mr. G. N. Saiwala, learned senior counsel
Saiwala.
assisted by Ms.
8, my lord, and first.
Ms. M. Saiwala, is it?
T.J.
T.J. Saiwala is present on behalf of respond number 8. Mr. R. Hussain, learned counsel, has appeared for respond number 7. And Ms. K. Yadav for respond number 12. The remaining respondents are absent. Full stop. The 2 writ petitioners hearing. Sorry? Appearance, give her appearance, write it. So your clients are landless people, river erosion affected. The 2 petitioners hearing claim to be landless persons affected by river erosion, alleging that the private respondents herein have been allowed to illegally encroach upon Sarkari land with the connivance of high authorities, high and influential authorities of the state, as a result of which the petitioners have been deprived from settlement of land. The instant writ petition has been filed, internally praying for a writ of mandamus, directing the respondents to rehabilitate the petitioners by making allotment of land in their favor after encroaching the private respondents. Mr. Talukdar, learned senior counsel appearing for the government of Assam, has produced a copy. Where is the notification? Submits that the government of Assam has now issued a notification,
6 January 21.
6 January.
has issued a notification on 6/1/2021, inviting applications for allotment of land in respect of landless persons by following the state's land policy.
No.
Yeah.
Erosion level.
For allotment of land in respect of erosion affected persons. And therefore, if the petitioners make an application, their request will be considered in accordance with law. First up, Mr. Saiwala, learned senior counsel appearing for the private respondent number 8, leading the arguments on behalf of the private respondent, submits that the allegations made in the writ petition are completely untrue. And therefore, the relief as prayed for cannot be granted to the petitioners. It is also the submission of Mr. Sahiwala that the petitioners do not have any right that can be enforced against the writ petitioners. Be that as it may. Since the petitioners are merely seeking allotment of land by virtue of their status, by allotment of land on account of the fact that they are river erosion affected persons, and considering the fact that the state has come up with a scheme to rehabilitate such river erosion affected persons, the other issues raised in the writ petition need not detain this court. In view of the submission made by Mr. Talukdar, this writ petition stands disposed of by granting leave to the writ petitioners to submit application for allotment of land. If such application is submitted by the petitioners within 3 months from today, the same be considered by the authorities as per the within quotes rehabilitation policy for erosion affected families of Assam, 2020, unquote, as notified by the government of Assam on 6/1/2021, and a decision be taken in respect thereof as expeditiously as possible, preferably within 6 months from the date of receipt of the application. Insofar as the private respondents are concerned, it will be open for the state to take appropriate action in the matter if they are of the view that there has been encroachment of Sarkari land, and this court does not make any observation or order on that behalf in the present proceeding. With the above observation, this writ petition stands disposed of. There is a IA. What is the IA about?
Lords, I was for early hearing, Lordship, that is instructions. Early hearing.
Check the IA. IA stands closed. Yes.
Obviously.
Huh? Give the appearance. Response number.
Item 8.
Yes.
May I please, Your Worship? So the petition is pertaining to the non-disbursement of cascaded loan, which was applied by the petitioner firm. Can
Cash
you-
credit loan 2013 matter is in fracture. Now it cannot be done. 2013, 10 years back.
Yes, fine.
Then if you are aggrieved,
Yeah.
go to the consumer forum. Writ court can't do anything about it. The matter is over for writ court.
Yes, my lord.
Yes. Your name, please.
D. Gogoi, my lord.
Heard Mr. D. Gogoi, learned counsel appearing for the writ petitioner. Also heard Mr. B.J. Mukherjee, learned counsel representing the respondent bank, bracket SBI. Being aggrieved by non-disbursement of cash credit
Cascaded loan. my lord.
loan,
Yes.
the writ petitioner had approached this court by filing the instant writ petition. Seeking a writ of mandamus directing the respondents to release the cash credit loan after completing all formalities, and also to pay compensation, damages and compensation due to the delay in releasing such loan. Full stop. This writ petition was filed in the year 2013, and in the meantime, more than 10 years have lapsed. As such, the petitioner, the question of issuing a writ of mandamus at this stage for release of cash credit loan would not arise. Full stop. Insofar as the relief for damages and compensation is concerned, the said aspect of the matter cannot be decided in a writ petition. If the petitioner is alleging loss and injury due to illegal action of the respondent bank seeking compensation, appropriate proceeding before the appropriate forum would have to be instituted for damages and compensation. Mr. Mukherjee, learned counsel for the respondents, has also submitted that no live issue survives in this writ petition at this point of time. In view of the above,
Time limit may be,
because
already.
and with the consent of the petitioner's counsel, this writ petition stands disposed of by granting liberty to the petitioner to avail alternative remedy, if so advised, for realization of damages and compensation, in accordance with law. Writ petition stands closed. Yes.
Item 9.
May I please? Also, due to various irregularities, also the financial power of the chairman of the Bopazar Road Municipal Board, his financial power was curtailed by the government, and the deputy commissioner was given. And during that period, he made also 22 illegal upgradation, regularization, and lots of that we have challenged. And lots of the government has also filed an affidavit admitting our stand lordship.
who are you?
Lordship, I am the vice chairman of the Bopazar Municipal Board at that point of time. And when the illegal regulations were
You
taken,
are still in office.
now at present, Lordship, nobody is in office.
Then what is there to be decided here?
Lordship, may kindly note of the fact, Lordship, the government affidavit, Lordship. Lordship, may I read?
When you were the, listen, it will help you. Otherwise, you make your submission, I'll pass the order in the chamber. Your client was was elected as vice chairman of Borpeta Road Municipal Board. When was that?
In 2013. For a period of 5 years.
That was for a period of 5 years. 2018, her term expired. Today, where is she? She's a chairman today or vice chairman?
That instruction, she may be that instruction I don't have.
All right. Now, what is the exercise of power by respondent number 6? That is the chairman of the board.
Chairman of the board.
You are agreed with the manner in which he had accessed power.
Yes.
That is no longer live because the new committee has come in. They will take decision in the matter. What can writ court do about it? By efflux of time, it has.
Lordship, may kindly take note of the fact, Lordship, in the affidavit filed by the government, Lordship, respondent number 1, 2, 3 has filed. Lordship, may I read this one paragraph, Lordship? Please,
You take up the matter with the present body. No writ can be issued at this stage. Against whom? He is no longer in office.
But the board is there.
Huh?
Borpeta Road Municipal Board is
You
there.
make a representation before the board.
And because of the Lordship restriction order, Lordship, their services have not been regularized.
Whose
They-
services?
The illegal appointment made by the chairman, Lordship, 22.
Oh, now that, you see, she is the vice chairman.
He is right.
So her term is over now.
My time is over.
Then
But this since.
heard Mr. S.K. Das, learned counsel appearing for the writ petitioner, also heard Miss R. Devi, learned,
For 5 and 6.
learned counsel appearing for respondent numbers 5 and 6. Miss S. Sharma, learned government advocate Assam, is present on behalf of respondent numbers 1, 2, and 3. None has appeared for the remaining respondents. Full stop. The writ petitioner herein was elected as the vice chairman of the Borpeta Road Municipal Board, Borpeta, in the year 2013 for a term of 5 years. During her tenure as the vice chairman, the petitioner had detected several illegalities committed by the then chairman of the board, that is the respondent number 6, which included illegal appointments made by the chairman of the board. And also, what are the grievances? Illegal appointments and
upgradation, Lordship.
upgradation of,
Lordship, upgradation of the staff, Lordship, temporary staff. Right.
upgradation of
Temporary
Yeah,
staff.
yes,
That
Lordship.
they are
Those are
holding
not-
the substantive post of LD.
service of
Staff.
staff, which according to the petitioner was not done by following the due process of law. Full stop. Aggrieved thereby, the petitioner had approached this court by filing the instant writ petition, seeking relief from this court. Full stop. The respondent numbers Where are the affidavits?
Lordship, affidavit filed by the Deputy Secretary, Urban Development Department, Lordship.
The respondent numbers 5 and 6 have filed affidavit in this case.
And no fresh appointment has been made, Lordship. These were some daily wage laborer who were
No.
against and they have anger.
I have given the resolutions, all the resolutions.
Denying and disputing the
Lordship.
averments made in the writ petition. Full stop. Be that as it may, the fact of the matter remains that the term of the petitioner in the office of Vice Chairman of the Barpara Municipal Board had expired in the year 2018. And so also is the case with respondent number 6, who was the then chairman of the board. Full stop. At present, a new elected executive body of the board is functioning. Therefore, the question of issuing any order against the respondent number 6 at this distant point of time does not arise in this writ petition. Full stop. If the petitioner, moreover, the petitioner does not have any individual right in the matter which requires to be enforced by issuing a writ in this proceeding. Full stop. If any of the employees of the board is aggrieved due to an illegal and arbitrary action on the part of the then chairman of the board, it would always be open for him or her to avail appropriate remedy. Full stop. Situated thus, this court is of the opinion that no live issue survives for adjudication in this writ petition at this point of time. The writ petition is therefore closed. The petitioner would be at liberty to avail appropriate remedy if any fresh cause of action arises in this regard. Yes,
Lordship, only one note, Lordship. The government has filed respondent 1, 2, 3 and has filed an
can be
affidavit
done.
saying that the
I will-
appointments are
If
illegal.
I go into that, I will stop that also. These are all personal rivalries, we know it. It's okay.
Public.
Public.
Item 11.
How many more matters? are there?
May I please? Lord, the impugned order, Lord, first impugned order, Lordship will find at page 13. This is Lord, ex parte order, my lord, page 13.
Hmm. Yes, what is the order?
Yes, page 13 on 3, my lord.
Yes.
Then, my lord, subsequent impugned order, my lord, at page 47 by the Board of Revenue.
Yes.
Yes. Now, here, my lord, operative part, my lord, Lordship will find
Hmm.
at page 48. Well, from middle portion, my lord.
Hmm.
From the above rule and regulation, it clear that the claims of the appellant for mutation and managed to get the CETA mutation in the year 2000 does not falls within the ambit of the section 50 of the Assam Land and Revenue Regulation. Since neither there was a transfer deed from the pattadar in place of the which the appellants was mutated, nor the appellants or the legal heir of the above mentioned pattadar respondents. So it is clear from the submission of the appellant that they had not acquired any title deed or they are not the legal heir of the pattadar. Their basis of the claim in their long possession.
but no revenue authority has power to grant mutation to a person only on the basis of his long possession, and only a civil court can pass effect order on the basis of the proved long possession. If the aggrieved parties filed civil suit under the specific relief act, so whether the additional deputy commissioner is illegally passed the impugned order ex parte or not is not a specific merit of the case, since the mutation granted in the name of the present appellant was based on only so possession without having any title.
What, based on only what? Only?
That is not admitted, not based on only. It should be not a continuous on possession that.
Continuous position.
Yes, on possession without having any title. In view of the above, we are of the opinion that the appellants are not entitled to get mutation on the basis of their long possession over the disputed land. Hence, we fact it not necessary to interfere with the impugned order and uphold the same. However, the appellants are at liberty to approach before the civil.
So what is wrong with it? This
Yes.
matter has to be decided in civil court. Why did you not go to civil court? So many years have gone. Who is in possession of the land?
But we are in possession, madam.
Go to civil court for declaration of title. Yes.
Already, my lord, there one civil title suit has been filed by the private respondent.
You are appearing for respondent number? Who has filed the title suit?
My lord, they have private respondent. They have. Lordship, they filed their affidavit in the affidavit, lordship, the paragraph number 4, they have clearly stated the title suit number, lordship, 239/12, 2012, lordship.
239 /
2012, lordship.
in the court of
Municipal number 1, Borpeta. They have filed in the affidavit, they have clearly said that they have filed WS in the, they said.
where is the statement? Let us see.
Yes, we have enclosed the Muller title suit, plain Muller, page 28 Muller,
Page 28.
page 28. We have enclosed Muller. This is the suit filed by the Muller private respondent.
You have filed written statement.
Yes, we have also filed written.
So then the outcome of the title suit will govern the rights of the parties. Heard Mr. M.O. Mondal, learned counsel appearing for the writ petitioners. Also heard Mr. J. Henry. You are as government or revenue?
Government lordship. So respondent number 2, 3 and 4.
N. Bordoloi, learned standing counsel revenue department Assam appearing for respondent number 1 and Mr. J. Henry, learned additional senior government advocate Assam appearing.
1 to 5 lordship, or 2 to 5.
Respondent numbers 2 to 5. Mr. M. Khan, learned counsel is present on behalf of respondent numbers 6 to 10. Full stop. The instant writ petition has been filed against the judgment and order dated 29/10/2013 passed by the Assam Board of Revenue, Guwahati, in connection with case number 42 RA bracket B bracket goes public 2012, dismissing the appeal filed by the present petitioners against the order dated 16/3/2012 passed by the additional deputy commissioner Borpeta in connection with miss case number 1 public 2011-12, cancelling the Chita mutation earlier granted in favor of the petitioners and restoring the names of the private respondents in the land records in respect of land measuring 05 bighas covered by DAG number 540/667 of PP number 228 of village Amguri under Rupsi Moja in exercise of powers under Rule 116 of registration, Rule 116 of the Assam Land and Regulation 1886. Full stop. While dismissing the appeal, the Learned Revenue Board has observed that the claim of the parties would have to be decided on the basis of finding of title, and therefore this was a matter which could be adjudicated only by the Learned Civil Court. Full stop. It further appears from the materials available on record that the private respondents hearing as plaintiffs have instituted title suit number 239/2012 in the court of the Learned Municipal, Borpeta, against the writ petitioners hearing, praying for a decree declaring their right title and interest over the suit land, and also for recovery of khas possession and for permanent injunction. Full stop. It further appears that the petitioners hearing, who are the defendants in title suit number 239/2012, are in possession of the land, and they have also contested the suit by filing written statement. It is submitted at the bar that the suit is pending disposal before the Learned Civil Court. If that be so, I do not find any justifiable ground for this court to interfere in the matter. First up, as such, this writ petition is hereby disposed of by providing that the rights and interests of the parties in respect of the land in question will be governed by the decree to be passed by the Learned Civil Court in the proceeding noted herein above. Full stop. Writ petition stands parties to bear their own cost. Yes.
Development.
Yes. Yes, what is it?
Please, my lords.
Yes.
My lords, the issue arises under the service tax law. We have come, my lords, on the basis that the order which we've impugned before my lords suffers from 4 deficiencies. My lords, one, the issue in question is covered by circulars of the board, which was specifically cited before the officer, but he has failed to administer those or apply those. Second, on the issue in contention, there is a judgment of the Honorable Supreme Court, which upholds a tribunal order, my lords.
Yes.
Which we had cited both the tribunal order and the order of the Honorable Supreme Court, which hold in favor of the assessee on merits as also on the issue of limitation. That has also entirely not been dealt with in the findings, my lords. And the third issue is that certain reimbursals were sought to be taxed, which is not entitled to be taxed if you are a pure agent under the law. We had cited the provision on pure agent and said that we are a pure agent. That argument also, my lords, has not been dealt with at all. My lords, therefore, we filed this petition. The issue came up in terms of whether it would be maintainable. That issue was dealt with by order of this honorable court on the 28th of July 23, my lords. And now this comes before my lord today. I am aware that on these virtual hearings, my lord was not probably able to hear. If my lord can hear me, I will proceed. If not, I will come before my lords whenever it suits my lord.
Now, you are arguing for final disposal today.
My lords, what I would believe is, yes, while I would push for final disposal, I believe that in the facts of this case, a remand would probably be, if it appeals to my lord, the correct approach, because several of these submissions, including board circulars, Supreme Court judgments, statutory provisions as cited, have not been dealt with at all. These could result in this order being rendered void ab initio, and therefore that it be set aside, or the issue would be that it be remanded with directions that all of this is required to be considered because by law, these are all binding.
Acha, Mr. Shah, is it? Am I?
Yes, my lords, my lord.
How much time will you take to argue this case?
My lords, it would take me about 45 minutes to an hour, my lords.
Okay, now there is an interim order in favor of your client, is it?
Yes, my lords, there is.
You see,
That is an order dated 12th July 22.
so what happens is due to some acoustics issues, it's very inconvenient for the court to hear long arguments on VC.
I appreciate, my lords. Would my lords then consider?
We are upgrading the system, but it will take about a month or so. So therefore,
I quite appreciate. Would my lords then give me a date on either the 12th of October or 18th of October, and I'll come in person?
18th of October, we can give you, but I will suggest that you avoid it because that will be just before the holidays, the long vacations of Guwahati. And that is a
would my
time,
lords-
you know, there is a big rush. So
Would my lords please consider the 12th of October?
we will fix it for final hearing then. We'll admit the writ petition and fix it for final hearing.
My lords, that is how it is set out today also in terms of the order of 28/7/23. It says for final disposal at admission. If my lords were to see that order.
All right,
I'm refer-
Mr. Shah, I would suggest that you have a date on 6th or 7th of November. That will be after the reopening of the vacation. And in case the matter goes on for a little while, because just before the puja vacation, half an hour is maximum you'll get. That might be convenient in a matter like this.
Would my lords
on the way.
either consider 5th or 8th, because 6th or 7th, my lords, I have a constraint.
Okay.
Sorry, my apologies. I believe the 6th is fine. I'm sorry.
6th is fine.
Yes, ma'am.
If you appear physically, then the court would want that you get enough time to argue your case and we wind it up. That's the reason.
I quite appreciate, my lords, and
your interest is otherwise protected by an interim order.
it is. My only situation is that this order, which is to my mind faulty on various grounds, continues to hold the field, and there might be subsequent proceedings.
No, I quite appreciate that. We'll have it thrashed out on 6th then. And we'll make it clear that it will be taken up for final disposal at this stage of admission hearing.
Very well, my lord. And the interim order to continue, my lord?
Interim order will continue, and if necessary, we can take it on the following day also if the arguments spill over.
Very well, my lord.
So you can make provisions for 6th and 7th both.
I will.
Not a bad place to.
No, one of the beautiful places in our country.
Yes, yes. Of course, if you wish to address on VC, then please inquire to your assisting counsel whether the new systems have come in. Otherwise, it
Very
is
well, my lord.
inconvenient for the judge to hear lengthy arguments. We have some acoustic issues here.
I appreciate.
10-15 minutes is okay, but anyway, so I heard Mr.
R. Saha, my lord.
R. Saha is the senior counsel.
No, my lord.
R. Saha, learned counsel assisted by Mr.
S.
Hazarika, learned counsel who has addressed this court in this matter through RVC. Ms. R.M. Decker, learned counsel, is present on behalf of the respondents. Mr. Shah submits that this matter is required to be taken up for final disposal. However, due to technical reasons, final hearing of this matter today through RVC is not found feasible. As such, on the request of the learned counsel for both the sides, register to list this case again on 6th of November 2023 as a fixed item in the column of disposal at this stage of admission hearing. If necessary, the matter will be taken up for hearing on day-to-day basis in view of the urgency expressed by the petitioner's counsel. Well, there is an interim order. Interim order passed earlier to continue until further orders.
Deeply obliged, my lord.
Grateful.